First of all, the Markkula Center for Applied Ethics is very excited to have everyone tuning in today to join us for this Get Vaccinated webinar. During the next half hour, we will be talking with a professor from Santa Clara University's School of Law about the different policies that employers have utilized as employees return to work, as well as the ethics regarding the different vaccination policies that are in place. To introduce myself, my name is Amana Liddell, and I will be hosting today's webinar. I am a senior at Santa Clara University, and for the last couple of months, I have been working at the Ethics Center to help with this Get Vaccinated webinar series. For today's webinar, An Ethical Approach to Vaccine Policies, we will be joined by Mr. Gary Spitko. Mr. Spitko is currently the Presidential Professor of Ethics and the Common Good and Professor of Law at Santa Clara University's School of Law. Mr. Spitko received his degrees from Cornell University and Duke University School of Law. After practicing law for several years and teaching at Indiana University, Mr. Spitko began teaching at Santa Clara University School of Law in 2002. Mr. Spitko, thank you so much for joining us today. We are very excited to give our audience a chance to hear from you.
Thank you, Amanda, and I'm happy to be here. Thank you for having me.
Of course. To start us off, could you please explain how an employer can legally mandate that employees get vaccinated?
Sure. Well, in short, employers do have that leeway for the most part to ensure that their employees are vaccinated. And that's because the background rule of American employment law is the employment at will principle. And that principle is simply that the employee and the employer can end their relationship at any time and for any reason. And we sort of add to it unless there's a prohibited reason. And so we start with the presumption that an employer can terminate the employee if the employee chooses not to get vaccinated, and for that reason can require vaccination. There are limits on the at-will principle, and one of the main limits is our civil rights laws. And there are two that have been relevant with respect to vaccine mandates, and in particular, Title VII's prohibition on discrimination on the basis of religion, and the Americans with Disabilities Act prohibition on discrimination against people with disabilities. So that's really where the sort of nuance and difficulty has come into play. But for the most part, employers can require that employees be vaccinated.
Okay. So with employers having that ability, what should private employers know about the legality of COVID-19 mandates in regards to the vaccine?
Well, the main thing that private employers need to understand is when they have to offer a reasonable accommodation to a sincere religious belief or a reasonable accommodation for a disability. And so, as I mentioned, Title VII prohibits discrimination on the basis of religion, and religion is defined broadly to include religious practices. And so an employer cannot discriminate against an employee on the basis of a religious practice that is sincerely held, unless the employer can show that that accommodation of that practice would cause an undue hardship. And so that's the term that we use, in undue hardship. And so in the context of religious discrimination, undue hardship means more than a de minimis burden. So it's a fairly light standard for religious discrimination. And then with respect to disability, it's the Americans with Disabilities Act that prohibits employers from discriminating against a qualified individual with a disability, where that person can perform the essential functions of the job with or without reasonable accommodation. So that's where the reasonable accommodation aspect of it comes in. The employer can have the defense that they can't offer a reasonable accommodation without undue hardship or without the employee posing a direct threat to themselves or to others in the workplace. And so what's a little bit interesting is that the term undue hardship, which is used in both statutes, both sort of bodies of case law, means something completely different under the ADA. So it's a much more difficult burden for the employer to meet under the Americans with Disabilities Act. So there you have to show that the reasonable accommodation would cause significant difficulty or expense. a much more demanding standard than de minimis. And so, so that's just sort of the broad outline of what employers need to understand. But then with respect to each category of requested accommodations, there are just a series of things that employers need to think about. So if we're talking about a request for a religious accommodation, the main thing you have to think about is this a sincerely held religious belief? And sincerity is basically a question of credibility. We often look at whether the employee has acted inconsistent with what they're suggesting now. So an example would be an employee is asking for Saturday off because it's part of their religious practice to take the Sabbath off. And it turns out they have another job on Saturday, and that's why they want the accommodation. Well, that's not a sincerely held belief. And then the other thing for employers to understand is that when we're talking about religious beliefs in the context of accommodation, it's a very broad definition. So it's not just, of course, the main religions, if you will, but the case law tells us it can be a new religion, a religion that doesn't have many adherents, and it can even be non-religious. So if it's a belief that holds the place in the life of the individual that the Supreme Being holds in the life of people who belong to one of the more recognized religions, then it qualifies as a religious belief. So that's basically what an employer needs to think about with respect to sincere religious beliefs. And then with respect to disability, the big question is, does the person have a disability? And there's a fairly complex definition of that, an impairment that substantially limits a major life activity. And each piece of that has sort of a case law behind it. But that's the basic idea. They have to sort of show they have a disability, and then it's the employer's responsibility to think about and to engage in an interactive process about whether a reasonable accommodation can be offered without undue hardship.
Thank you. So kind of elaborating a little bit more on those religious exemptions, the sincerity piece really sticks out to me as that's something that's, I think, really difficult for employers to navigate and kind of validate, especially when there are people who are using that religious exemption to get out of the vaccine policies without having that sincerity piece. But that's something that is then hard on employers to validate. So what should mandatory vaccine policies say with regard to these religious exemptions to ensure that employees aren't abusing that ability to use religious exemptions?
Well, I mean, I think the first thing a policy needs to say is that the employer is open to offering a reasonable accommodation to sincerely held religious beliefs. And in reality, employers often don't want to get into the question of, is this a sincerely held belief? And honestly, courts don't want to get into that aspect either. It's a little bit uncomfortable to be questioning whether somebody really has a sincerely held religious belief. So we tend to sort of try to focus on other aspects, like, is there a reasonable accommodation necessary? But if you really wanted to think about it, again, the main sort of way we might judge this is, has the person acted inconsistently with what they're now claiming? But then we often ask, is what they're asking for sort of a very valuable accommodation outside of the religious context? Have they asked for this before without tying it to a religious accommodation, been denied, and so now there's an accommodation? But it's really just you sort of look at the totality of the circumstances, and it's a credibility judgment. And but again, I think most employers are reluctant to conclude that the employee doesn't have a sincerely held religious belief. And in fact, you're not really supposed to ask unless you have some objective evidence of a lack of sincerity. So the cases tend to play out more on, and again, people don't want to fight about whether something's a religious belief either. And so, you know, the worker doesn't actually have to belong to an organized religion, doesn't have to show that they, you know, attend mass regularly. It's really just a question of essentially, is it a religious belief as opposed to a social and economic belief, or a personal sort of objection, which is not covered. And so one way that employers, I think, evaluate these requests is to ask the worker to sort of write out a statement of why is it that you need this accommodation. And then we look at the statement and we think about well, is this really about a personal philosophy, a social philosophy, a political philosophy? So if the answer is, my political party is not really supportive of vaccine mandates, then we know that this is not a religious objection as the case law defines it. And so that would sort of take that outside of the accommodation mandate. So that's
Great. Thank you for answering that. It's definitely a difficult place for both employees and employers to be in when it comes to exemptions from their vaccination policies.
right.
So going on, what are the privacy rights that employees have in regards to their vaccination status when an employer requires that they provide proof of vaccination?
Well, I often hear, doesn't HIPAA, so doesn't the Health Insurance Portability and Accountability Act, doesn't HIPAA protect my right to not disclose this or not share this information with my employer? And the answer is no. HIPAA has no, it doesn't relate to the employment relationship. It doesn't cover the relationship between employer and employee. The protection that comes in is under the Americans with Disabilities Act. And the Americans with Disabilities Act says that while an employer can ask whether the employee can perform the essential functions of the job with or without a reasonable accommodation, you're not actually allowed to inquire into disabilities. But when that issue came up with respect to COVID-19 vaccine mandates and questions, the EEOC has said that inquiring into vaccine status is not a disability inquiry. And so the ADA won't prohibit employers from asking that question and demanding an answer to that question. Are you vaccinated? Have you tested negative or positive? But what the ADA also does require is that employers protect the confidentiality of health information. And so that information that you give, yes, I'm vaccinated, yes, I tested positive for COVID, is protected. And among those protections, the employer has to keep that information separate from the employee's personnel files and treat it as confidential, which means that folks don't get to see it unless there's a need to know. And they're also supposed to be training people who are working with this information as to the responsibility to keep it confidential and how to keep it confidential.
Great, thank you. Because I know that's been definitely a question of if that was covered by HIPAA or not. And so kind of talking a little bit about a special kind of employer, I guess, can the federal government mandate the vaccine for federal workers?
The short answer is yes. And so everything that we've talked about so far with respect to Title VII and the ADA applies to state and local governments. So the ADA covers state and local governments, Title VII covers state and local governments. So with respect to a state government, the analysis is at least initially somewhat similar. The federal government is also subject to Title VII in employment. There's a different enforcement mechanism, but the basic principles apply there. They're not subject to the Americans with Disabilities Act, but they're subject to something called the Rehabilitation Act of 1973. And frankly, the ADA was sort of patterned on the Rehab Act, and a lot of the definitions in the ADA come from regulations under the Rehab Act. So the basic structure is the same. Government employers are subject to those civil rights laws, which means that, yes, they can require a vaccine mandate, but they do have to provide accommodations for sincerely held religious beliefs and for disabilities that can be accommodated without undue hardship or, in the case of disability, a sort of direct threat to the health and safety of the worker or others. In addition, a government is subject to constitutional limits. So, for example, the First Amendment has a protection for religious free exercise, and that would also sort of come into play. The Fourth Amendment prohibits unreasonable searches and seizures. So some suits might be brought there. The 14th Amendment protects, I'll just sort of say liberty to make it simple. And so some of the lawsuits have been brought saying, I have a liberty interest in not being vaccinated and not being subject to this mandate. In short, almost every single lawsuit that has been brought to challenge the vaccine mandates that were imposed by local, state, the federal government have been resolved at least either temporarily or permanently on behalf of the government. And the basic idea is the government has a really compelling interest in the health and safety of the workplace, of society. And there's this case law from 1905, a case called Jacobson versus Massachusetts, where the US Supreme Court held that there really is no fundamental right to refuse a vaccine. That case dealt with smallpox, and Massachusetts requiring folks to get vaccinated for smallpox and people who were objecting to it. And the basic case law is that the government has the right to tell people you have to get vaccinated. And the employer, the government as employer generally has more rights, more leeway than the government as sovereign. So the government as employer can infringe, for example, in speech rights that the government as sovereign never could. So where these state and local governments have really come into some difficulty is when they haven't provided a pathway for religious accommodation. And so there are a number of cases. The state of Maine has decided healthcare workers have to be vaccinated. And we've just sort of done our calculus beforehand, and we're not going to offer any religious accommodations. We'll offer disability accommodations, the thinking being if people really have an allergic reaction to the vaccine, it's not good to have them vaccinated and become unhealthy themselves. But when we do the weighing that we need to do, it comes out we're not going to offer a religious exception. And actually in that main case, the First Circuit has actually said that's okay. But there have been a couple other cases where courts have enjoined the refusal to offer religious accommodations. But for the most part, federal, state, local governments can require their workers, not just their workers, but healthcare workers in general, students at universities have filed in lawsuits, can require folks to get vaccinated. Yeah.
Okay, thank you. I do want to ask a question that was asked in the Q&A. So the question is, what should an employer's approach be to in a situation where reasonable accommodation has been made for someone who is exempt from the vaccination mandate that an employer has put in place, and they have remained an employee, but for some of the employee-sponsored benefits, they must be vaccinated to obtain them. For example, like an access to an on-site gym or other benefits requiring vaccinations. Are exempt employees still entitled to those types of benefits, or is it just their employment status?
Yeah, so the key to thinking about reasonable accommodations is you have to think about each employee, like what is their situation, whether it's a religious objection or a disability that needs to be accommodated, and what is the employer situation. Which, all kinds of things come into play. So there really is no answer that one could give or should give that says, here's a blanket policy, we're going to just apply it to everybody. In theory, you at least need to think about the particular circumstances. So you might think about, does this employee work inside or outside? Do they work closely with folks or not? Those kind of things. The fact is, if the employer has offered a reasonable accommodation, that accommodation might be, so I'll just pick something. You get to telecommute, you get to work at home. That might include, you're not allowed in our facilities, you're not allowed in our gym. And again, the burden on the employer with respect to religious accommodation, I don't remember if your question said it was a religious accommodation or disability, but is quite minimal. And I think the key thing to remember is once the employer has offered a reasonable accommodation, the employee doesn't have a right to object and say, I'd like a different accommodation. It really is almost like a take it or leave it situation. And so an employer might come to the decision, we're going to offer this accommodation. You can work at home, or, you can work on campus, but in your own office, but you just can't be in the gym. And that would be fine. Again, you really can't answer that question without thinking about what is this employee situation? What does the gym look like? Is it an outdoor gym? Those kind of things. But in general, employers have a lot of leeway with respect to what is a reasonable accommodation. The key is engaging in an interactive process, talking to the worker about, what is your concern? What are your needs? How can we fix this? But once the employer comes up with a reasonable accommodation, the employee really can't ask them to tweak it. You can always ask, but you don't have a right to get that tweak.
Yes, that's good to know. And I think that kind of brings up the importance of understanding that a lot of these situations are very nuanced and unique. So it is important to not make those kind of blanket statements because every situation is different. And so it's important that we kind of understand the science backing what activities are riskier, what like environments are riskier than others. And so it really brings up the importance of also understanding the science as employers as well.
Right.
Um,
I couldn't agree more. And also the particulars of the employer. If we're thinking about an employer that has 50 employees versus an employer that has 50,000 employees, and here we're thinking about resources, what might be reasonable for the smaller or for the larger employer because of their resources would not be reasonable for the smaller employer. So you have to think about both sides of the equation, individual inquiries.
Yes, thank you. And so you kind of touched on this in your answer to the last question, but can employers require employees to work remotely if they refuse to get vaccinated?
Yeah, so the EEOC in its guidance with respect to COVID has suggested that remote working is a potential reasonable accommodation. And so again, we start with the premise that the employer can terminate somebody because it's Tuesday and they want to fire the first person who walks through the door. There really is no limit unless there is a limit, and so they can require a worker to work at home unless the worker shows I have a sincerely held religious belief that needs accommodation, or I have a disability that needs accommodation. And if they show that, the employer then can think about, can we offer a reasonable accommodation? And in the context of, without an undue burden, right? An undue hardship. In the context of COVID, that's one of the accommodations that the EUC has suggested is reasonable. So if the employer decides this is the route we want to go, again, the idea is you have to engage in an interactive process with the worker. But if that's the reasonable accommodation that's been offered, the worker really doesn't have a right to say, oh, I'd rather have testing every week, or I'd rather wear a mask and stay in my office. It's really up to the employer to make that decision. So the answer is yes, the employer can do that. Yeah.
Okay. And so kind of on the flip side of that is if an employee does not choose not to get vaccinated and they do have some sort of accommodation, can the employer then require that the employee be tested regularly in place of their vaccination?
Yeah. So again, an employer can require everybody to be tested on a regular basis, unless there's some reason not to. And you may have a religious objection to the vaccine that doesn't really apply to being tested. You may have a disability with respect to the vaccine. You're allergic to some of the ingredients that doesn't really have any application with respect to being tested. So we may not even get to the question of, reasonable accommodation with respect to that kind of a mandate. Everybody needs to be tested. But again, if the requirement for testing has arisen because it is the reasonable accommodation that the employer has offered after engaging in an interactive process, then the answer is yes, that we sort of allow the employer to make that decision, and the employee wouldn't really have a right to object to it. Now, I can't, as I'm sitting here trying to think of what the religious objection would be to testing, or what the disability, I mean, I've been through the testing, it's not all that onerous, would be. I can't think of it here, but maybe there is such a religious accommodation request or a disability request, and then you just go through the same analysis with respect to like, I don't want to get the vaccine, I don't want to get the testing. You'd have the same kind of balancing there as well.
Okay, thank you. And so then I guess another question is, can private employers fire someone who does refuse to get vaccinated? Like you said, in Maine, they don't allow religious exemption. So if someone in that situation didn't want to get vaccinated despite that, would an employer be able to fire them?
Yeah, so again, we're going to assume that the employee has been able to show that they have a sincere religious belief, or they have a disability that needs to be accommodated. If they don't, which I would suspect is the vast majority of people who might not want to get vaccinated, there's no real restriction on the employer firing that person, even if the worker has some other job protections where they can't be fired without just cause, and that's a very small group of workers, like, for example, law school professors. The idea that you are potentially posing a threat to the safety of people in the workplace might allow the employer to terminate that person. So if they can't show they need an accommodation, I think it's not a problem to terminate them in terms of the law. If they can show they need an accommodation, then the question is a reasonable accommodation possible without an undue hardship or without the worker posing a direct threat to the safety of others or themselves in the workplace. So that's the analysis we would go through. And in many cases, because of the particular nature of the job, it may well be that a reasonable accommodation can't be offered. So, if you're an accountant working sort of with books at home, maybe that's okay. But if you're, a surgeon operating on patients, you really can't do that from home. So the same employer might decide we can let this person have an accommodation. We just can't accommodate this, and this person's going to have to be let go. Yeah.
And I think that brings in a very good point of vaccine mandates, and the vaccine in general are in place to help keep everyone safe. And really that's what's in mind. And so it's very difficult when you have been vaccinated or the people around you have, for the most part, been vaccinated. And then you might be put at risk by someone who's not vaccinated coming into work every day, who could be putting you, or if you have small kids at home who aren't able to get the vaccine yet, at risk as well. And so I think that's another very important point of why it is important that we do get vaccinated if we are able to.
Right. Right.
And so with the few minutes that we have left, one question that I want to pose is, how should an employer respond to an employee who's resistant to returning to work in person in fear of COVID-19?
Well, I think the first thing from the employer's perspective, when the employer is thinking, as a lawyer, you'd want to know why does the employer feel uncomfortable? And that is to say, so it's maybe seem odd, but under Title VII, the employee doesn't actually have to ask for a reasonable accommodation. If the employer suspects they need a reasonable accommodation and they take an action, then they can get in trouble. So when someone says, I don't want to come back, I think the first question the employer might want to ask is, why? What are your concerns? And then even if, of course, that may trigger the requirement to engage in an interactive process with the worker. But even if the answer is, I don't have a disability, I don't have a religious objection, I'm just worried about getting COVID and being in the office, then I think the answer is have a conversation with that worker about, what exactly are you concerned about, and maybe how can we address it. I don't know if there's a legal obligation on the employer to address it, but as a good employer, you might want to just talk to your workers about what are you concerned about, and maybe there's some solution that can be worked out with the employee. That'd just be my recommendation. Yeah.
Thank you. Yes, that's still good for us to know. And then with the few moments that we have left, do you have any closing thoughts or remarks that you would like to share with our audience before we go?
Just that I think I'll sort of stick with that thought about communication is key, both from the perspective of the employer and the perspective of the employee. So I think it's really important for employers to communicate, why are we having this vaccine mandate and why are we having testing, to really communicate that we will respond to and evaluate sincere religious belief objections that need accommodation or disabilities that need accommodation, to communicate about how you apply for those things, communicate about who's going to be sort of evaluating them, make sure that those people are trained to evaluate, and then communicate clearly the answer, like, yes, you got your accommodation, or no, you didn't get your accommodation, and why. So the other field I work in is conflict resolution, and just the process can often be as important as the substance. And so I'd say for employers, think about the process, think about how the process is making workers feel, and that will go a long way.
Yes, I think communication, considering someone else's perspective or perception of something, it can definitely go a long way in our communications with others. Mr. Spitko, thank you so much for joining us today and sharing all of this valuable information with our audience.
Thank you, Amanda. I enjoyed it.
Thank you. And so coming up next in our series of Get Vaccinated webinars, we will be talking with Assistant Professor Melissa Brown on November 11th. She is a professor from the Department of Communications at Santa Clara University. And during this discussion, we will focus on the effects of misinformation, how we should address it, and how it manifests in marginalized communities. Thank you all for tuning in today, and we look forward to seeing you next time. Bye.